Indian Evidence Act. APP Milind Datrange sir has completed his LLB from NBT Law College Nashik and has started practice as an advocate at Sangamner. Sir was lecturer at SPS Law College Sangamner, district Ahmednagar, and has taught CPC. Sir was selected as an assistant public prosecutor in the year 2006 through MPSC and has served at Solapur, Mumbai, Pune, Palghar, Navi Mumbai, Satara, etc. Sir has delivered lectures to the police officers regarding investigation of criminal cases at the places where he has served in Maharashtra. Also, sir has delivered lectures on Indian Evidence Act and its relevancy in investigation of crime to the police officers who appeared for AIPDM. Sir has written books for legal guidance to police officers and assistant public prosecutors at Maharashtra Police Academy, Nashik, and has also written a book for legal guidance to assistant public prosecutors working in state of Maharashtra. Sir has delivered lectures on various legal aspects to assistant public prosecutors, has delivered online lectures on Indian Evidence Act, CRPC, IPC to police officers and assistant public prosecutors. Also, during this pandemic situation, sir has delivered numerous lectures on legal topics to the JMFC aspirants and to young lawyers. Sir has conducted various civil and criminal cases. And one more thing, when sir was firstly posted at Solapur, he has started a discussion group for young lawyers who are aspiring to become judges or public prosecutors, or even who wants to practice. And because of that discussion group, out of the discussion group, number of participants were selected as judges and public prosecutors. I am one of the luckiest person that I was student of sir and I am student of sir. When sir was at Solapur, sir blessed me with his knowledge, and because of that, whatever I am today, because of sir, I request Datrange sir to start with his speech on relevancy of facts under Evidence Act in connection with JMFC examination.
Good evening to all my brothers and sisters. Honorable Shri Ganesh Pawar, so also respected Chairman of the Bar Council of Maharashtra and the members of the Bar Council of Maharashtra. First of all, I am expressing my thanks that this opportunity to me to discuss with you on various aspects relevant to relevancy of the Indian Evidence Act. One of the basic definition, that is relevancy. Friends, we know the definition is given in section 3 of Indian Evidence Act. I came to know that as you are appearing for the examination of Judicial Magistrate First Class, so this act is very important because the Indian Evidence Act is applicable to civil cases, also criminal cases, and other aspects also. There are parts of this act, but so far as relevancy is concerned, as the issue relevancy which is given to me, and today I will discuss on relevancy. So we will focus on definitions given under section 3, then presumptions given under section 4, and the relevancy which is given by section 6 to 55. In fact, there may be a question in your mind that why not section 5 to 55, but section 5 is quite different, and hence I will discuss on section 5, but I want to say that relevancy which is given by section 5 to 55. As you are appearing for this examination, first of all, I want to invite your attention on the very first line, or we may say that the opening line of section 3, that is the interpretation clause. So see the difference in between this act and other acts. So far as the construction of various acts, section 2 is for definition. But so far as present act is concerned, Indian Evidence Act is concerned, Section 3 says about interpretation clause. So there is quite a difference in between definitions and interpretation. So what is interpreted by section 3? We have to apply our mind. Words and expression is interpreted. Opening line of this act is, in this act, the following words and expressions are used in the following senses unless a contrary intention appears from the context. So unless and until any contrary intention appears, we have to go through the words, the interpretation of the words, the interpretation of the expression. So first of all, I'm inviting your attention that how many words interpreted by section 3 and what is the expression which is interpreted also by section 3. Word court is interpreted. Then the very significant word fact. Fact means and includes. Opening words says about means and includes. So wherever means and includes, please go through the scope which is behind by means and includes. There are judgments to this aspect. What mean by means and includes? This is not a simpliciter means, or this is not a simpliciter includes. Fact means and includes anything. Then it is mentioned here, state of things, relation of things, capable of being perceived by the senses. Capable, see the capacity, capable, who is capable? Capable of being perceived by the senses, senses of a human being. So far as word senses or sense is concerned, to focus on this word senses, I want to invite your attention on section 60 of this same act, Indian Evidence Act. Section 60 is for direct oral evidence. Oral evidence must be direct. That is to say, when a person who saw it, he must say that he saw it. If a person who heard it, he may come before the court to say that he heard it. And if any person is pursued by any means or by any senses, the person may come before the court for a deposition to say about it. So this is the significance of word sense, which is related with section 60, and word sense is given in the interpretation of fact. Fact means and includes anything, state of things, relation of things capable of being pursued by the senses. Second part of this definition, fact means and includes any mental condition of which any person is conscious. Conscious mental condition is expected here. Sense is related with the mental condition, which is expected by second part of the definition. While observing relevancy or while observing entire Indian Evidence Act, I want to say that unless and until the reader knows about appropriate meaning of the definitions, or practically I have to say that the interpretation of the words and expression which is expected by the opening lines of section 3, the reader is not a competent person to understand Indian Evidence Act. This is my personal experience. After reading near about 700 to 800 times of Indian Evidence Act, I want to say that one must know definition of fact, what mean by fact, then the definition of relevancy. One fact is said to be relevant to another when the one is connected with the other. See the nicety of the word, connection, connected. At the same time, I want to say that it is necessary to focus on the word corroboration. Connected and corroborated. Both these words are significant. So far as relevancy is concerned, and relevancy, how to measure the relevancy, where the relevancy is given, the relevancy itself given by section 6 to 55. So to understand relevancy, one must know the definition of relevancy, interpretation of the word relevancy. One fact is said to be relevant to other when the one is connected with the other by the ways which are given under Indian Evidence Act. So one must know section 5 to 55 in detail. There are various aspects I will discuss with you within the time of span which is given to me. I will try to discuss with you the nicety of various sections. But prior to that, once again, I want to say that one must know the definitions and the interpretation of any act. So far as Indian Evidence Act is concerned, the definitions are very, very, very significant. Fact, definition of fact, then definition of relevancy, and then the interpretation of the expression. I am specifically using word expression, that is facts in issue. Facts in issue is an expression, and word court, relevant, document, evidence, proved, disproved, not proved. These are the words interpreted by Indian Evidence Act. Only one expression, that is facts in issue. Very significant. Facts in issue. One must know what mean by facts in issue to understand the case. To understand the case arising out of any penal provision, or the case comes in the ambit of any penal provision, or civil, but whatever it may be, or revenue, you may say. Facts in issue. Now, so far as the issue is concerned, we have to focus, first of all, on Order 14 of Civil Procedure Code. Order 14 says about issues, framing of issues, burden on parties, framing of issues. When framing of issues, some issues are on plaintiff, and if some issues are on defendant, then we must know Order 18 Rule 3. Who may give evidence? Order 18 Rule 3. See, this is the connection. While reading facts in issue, two aspects: civil, criminal. So far as civil is concerned, Order 14, that is for issue. Burden is concerned, once again, section 101 of Indian Evidence Act. So far as burden is concerned, 101, 102 to 106, burden. Some other sections are there. And significant, Order 18 Rule 3 of CPC. Who may start? Either plaintiff or defendant. It depends on the issues. Onus is a different aspect. Burden and onus. So far as criminal side is concerned, so far as CRPC is concerned, so far as facts and issue is concerned, we are discussing on facts and issue. One must know section 211 to 224. 211 to section 224. Framing of charge. Framing of charge. What mean by charge? Definition of charge is given by section 2 of CRPC. So also the elaboration, which is given by section 211 to 224 of CRPC. Various sections are there to say what mean by charge, how to frame charge, and at the same time, I'm inviting your attention on various penal provisions given under Indian Penal Code. Form of charge. So as you are appearing for this examination, I will request you, please go through the form of charge also. Please note down the form of charge. Please write the form of charge. There are ways to study, types of ways to study. Pratyekachi style, pratyekachi vegri ase. I will suggest you read and write to understand. Very calm and quietly read. At the same time, write. Please understand the full stop. Please understand semicolon, y colon, the punctuation marks, and then you may develop yourself. Facts in issue. So far as facts in issue, right, liability, and disability are the three terms discussed in this interpretation. right, liability, disability. Asserted or denied. See the words. Assertion. So far as civil is concerned, assertion by plaint. Assertion by pleadings mentioned in the plaint. And to that regard, one must know order 6 for pleadings and order 7 for plaint. Asserted or denied. At the same time, one must know the burden which is on prosecution. At the same time, burden which is on prosecution. And to this regard, I want to invite your attention on Article 20, Subarticle 3 of the Constitution of India. So far as burden is concerned, so far as beyond all reasonable doubt, we know this term. And to focus this term, I want to invite your attention on Article 20, Subarticle 3 of the Constitution of India. Then the next word which is given under Indian Evidence Act is document. Very important term, document. Express upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used for the recording of that matter. This is the definition of document. Definition of document, though given under Section 3 of Indian Evidence Act, but at the same time, definition of document is given under IPC also. Please read General Clauses Act to understand various definitions. Various definitions are given by the General Clauses Act. General Clauses Act, Central Act, and one General Clauses Act is for state of Maharashtra. So I want to suggest you, please go through General Clauses Act, which is for all means India, and so far as our state is concerned, General Clauses Act, which is applicable to state of Maharashtra. Definition of document and definition of writing is provided by General Clauses Act. So please go through both the General Clauses Act. We are observing document by means of letters, figures, or marks. Intention of expression. So document generally फक्त कागद पेपर म्हणजेच डॉक्युमेंट नाही. Letters, figures, or marks expressed upon any substance. So please focus your mind on any substance. Any substance. That is document. Definition of document is given by Section 3, then Indian Penal Code, then General Clauses Act, and please go through Section 95 of CRPC to understand definition of document. Though definition of document is given by Section 3, but one more definition of document is provided by the same act, that is Indian Evidence Act, by way of provisions of Section 65, capital B, subsection 1, 65 capital A and 65 capital B. Computer output. Definition of electronic document. Printed, copied, stored on optical or magnetic media. Computer output. ज्यांचे व्हिडिओज सुरू असतील त्यांना एक नम्र विनंती आहे, व्हिडिओ प्लीज बंद करा. ज्यांचे व्हिडिओज सुरू आहेत त्यांना एक विनंती आहे, व्हिडिओ बंद. थँक्यू. So please apply your mind on Section 65, capital B, subsection 1. To focus on the definition of document. So while reading definition of document, which is or interpretation of document, which is given by Section 3 of Indian Evidence Act, a good reader must know the provisions of subsection 1 of Section 65 capital B, at the same time 65 capital A also. So for a document is concerned. At the same time, I want to suggest you, please go through entire chapter 5 of Indian Evidence Act, proving of document. So first of all, one must know what mean by document. What mean by regular document? Very specific word used by me, regular document. Regular document means the documents which are described by the interpretation of the word document by section 3. But at the same time, a good reader must know the definition of document which is given by section 65 capital B subsection 1. It is mentioned in that subsection 1 that shall be also a document, but when, if, the word if is very important. Shall be also a document. So see, shall be also a document. Why? Legislature has mentioned the word also. Shall be also a document if the conditions which are mentioned by subsection 2 to subsection 5 of section 65 capital B are fulfilled, then only one can say that the computer output is a document. Computer output is secondary evidence. And to prove computer output, certificate under subsection 4 of section 65 capital B is required. It is necessary to prove such certificate by the person who is expected by subsection 2 and subsection 4 of section 65 capital B. Needless to say that Indian Evidence Act. I will not repeat it because I am discussing on you Indian Evidence Act. It is necessary to prove the contents of certificate. Certificate is document. So whenever proving of contents of any document, please go through section 67. It is necessary to examine the author of any document to prove the contents of document and signature on the document. If the author is not available due to any reasonable reason or due to any reason which is reasonable, then it is necessary to go through some of the sections. Section 68, 69, 70, 71, 72, and then so far as expert is concerned, section 73, and so far as electronic evidence is concerned, section 73, section 73, capital A. This is the way to prove the document. I know that I want to discuss with you on relevancy, but this is my habit. Whenever any issue is before me, मला ती सवय आहे जरा बोलण्याची, म्हणून मी ते सगळं बोलत असतो. We are on the definition of document. So this is the discussion on definition of document. Now discussion on the word evidence. Next word is evidence, definition of evidence. Oral evidence and documentary evidence. Statement before the court. Statement before the court means the statement before the court on oath. So far as evidence is concerned. As we are discussing the expression document, two words are very significant. Word permits and requires is mentioned in the definition of evidence. Permits or requires. So opening line, evidence means and includes, once again the same situation, means and includes, as I discussed when I discussed facts in issue. All statements which the court permits or requires. Now what is the meaning of permits or requires? Why these two words are here? Court permits, court requires. So far as permission is concerned, please go through Order 18 of CPC. So far as CRPC is concerned, please go through sessions trial, warrant trial, summons trial, and summary trial. There are two parts of warrant trial. Cases arising out of police report and cases not arising out of police report. That is the complaint case. Comes in the ambit of definition of section 2 small d, read with section 200 of CRPC. So far as complaint is concerned. At the same time, at this juncture, I want to share with you that please understand the scope or the difference of FIR and complaint. What mean by FIR? Section 154 CRPC FIR, section 200 CRPC complaint. This is this difference in between FIR and complaint. We are at definition of evidence, oral evidence and documentary evidence. We are discussing two words, permits or required. What mean by permits? We are discussing the word permits. Permission by the court to adduce evidence. Permission by the court to adduce evidence. I am discussing with you the codified law, CRPC, so far as CPC. Provision, Order 18, given by CPC, and 4 trials by CRPC. So also, important section 311 of CRPC. Permits. There are two parts of section 311 of CRPC. So far as first part is concerned, which is the discretion, that is may. But so far as second part is concerned, that is mandatory shall or directory. You may say directory by the word shall. Permits or required. Court may permit, court may require. No, court may permit. Now court may require. So far as require is concerned, I want to invite your attention on the definition of may presume. Please go through the definition of may presume and please apply your mind. Last line. Court may call for proof of it. This is the last line of the definition of may presume. Court may call for proof of it. So court may call, requires. Please go through section 165 of Indian Evidence Act. Court may call witness. Court may call things. It's a special power given to the courts to call witness if the party is withholding any witness mistakenly or deliberately or intentionally. So honorable courts are there to call the witness by way of using of complementary provisions to each other. Second part of section 311 of CRPC, read with section 165 of the Indian Evidence Act. This discussion is for the first limb of the definition of evidence, oral evidence. So far as oral evidence is concerned, section 59, which is very important section, section 59. Proof of facts by oral evidence. See, we are discussing definition of evidence. We are discussing oral evidence. Section 59 says all facts except the contents of documents or electronic records may be proved by oral evidence. I am reading this section once again. All facts may be proved by oral evidence. This is the section. All facts may be proved by oral evidence except the contents of documents or electronic records. So why this exception? Except the contents of documents or electronic record, as provisions of section 91 to 100 are given by the Indian Evidence Act, exclusion of oral by documentary evidence, and hence this exception. Otherwise, this section simply says all facts may be proved by oral evidence. Next section, section 60, just I discussed with you. Oral evidence must be direct. So these two sections are very important to read with. First part of the definition of evidence, that is oral evidence. Second part of definition of evidence, that is documentary evidence. Just I discussed with you, document, types of documents. A separate lecture is required for this purpose, to discuss on documents. What mean by document? Then public document, private document. Please go through section 74 and 75 of Indian Evidence Act. How to prove documents, very important aspect. How to prove contents of document. How to prove signature appearing on document. At the same time, though I just discussed with you chapter 5 of Indian Evidence Act for proving of documents, at the same time, I am inviting your attention on section 47 of Indian Evidence Act so far as expert is concerned. Expert or person acquainted is not a technical expert, because so far as document is concerned, technical expert is provided by section 45, read with section 73 of Indian Evidence Act. But the person who is not technical expert, but who knows the signature of a specific person, as he saw the signature, or he knows the signature by practice, again and again he watched the signature and he knows that this signature is belongs to this person. Parties may examine such person also. And for this purpose, I am inviting your attention. Please go through section 47 of Indian Evidence Act. When you are reading section 47 of Indian Evidence Act, go through section 60. And when you are reading section 60 of Indian Evidence Act, please go through section 47. Correlation in between section 47 and section 60. We are discussing definition of evidence, and we are discussing second part of the definition of evidence, that is documentary evidence. And so far as proving of document is concerned, once again, I am inviting your kind attention. Please read again and again. Please write again and again. Please read again and again. Entire chapter 5 of Indian Evidence Act. We must have mastery on chapter 5 of Indian Evidence Act. Very significant chapter, which says about how to prove documents. So first of all, one must know what mean by document. Just I discussed with you. Definition of document are given, and proving of contents of document at the same time. So far as proving of contents of documents, please go through the relevant provisions provided by civil manual, so also criminal manual. Please go through chapter 6 of criminal manual to understand how to prove document and how to exhibit document. How to exhibit document. Exhibiting of document is a significant aspect. We know it well. So how to prove the document, and at the same time, why exhibit number is necessary. And when exhibit number is necessary, why exhibit number is necessary, at the same time, when exhibit number is necessary. So please go through the relevant provisions which are given by civil procedure, civil manual, so also criminal manual. After the definition of document, may proved, disproved, and not proved. Proved, disproved, and not proved. One fact is said to be proved, considering the matters before it. It is mentioned by this definition, matters before it. It is not mentioned in this definition that the evidence is evidence before it, because parties are adducing evidence, oral evidence and documentary evidence. If documents comes in the ambit of section 91 to 100 of Indian Evidence Act, according to latent ambiguity and patent ambiguity, the question is whether it is necessary to prove the contents or not. It depends on both the ambiguities. So at the same time, please understand what mean by latent ambiguity and what mean by patent ambiguity. Latent ambiguity and patent ambiguity. Into that regard, please go through section 94, 95, 96, 97, and 99 of Indian Evidence Act, and please read the illustrations which are given below these sections. As the discussion on illustration is come up, I want to say that to understand IPC, to understand Indian Evidence Act, please read the illustrations. There are various illustrations given below various sections. For example, please go through the illustrations given below section 8 of Indian Evidence Act, section 14 of Indian Evidence Act, and then section 114 of Indian Evidence Act. If you go through section 114 of Indian Evidence Act, you may ascertain that there are illustrations A, B, C, D, E, F, G, H, I by straight way, and A to I by different way. So please go through illustrations. We are at documents, documentary evidence, and then proved. Matters before it. The term matters before it is mentioned in the definition of proved and disproved. What mean by matters before it? Things are also before the court to prove the things, weapons, clothes, various things. So far as things are concerned, I'm inviting your attention on last proviso of section 60 of Indian Evidence Act. Please go through the last proviso. There are two provisos. The second proviso, that is the last proviso. Last proviso of section 60 of Indian Evidence Act to ascertain adducing of evidence relevant to the things, various things. Weapon also thing. So how to prove the weapon? How to prove the weapon? Because witness may say about the weapon. Oral evidence of the weapon. Weapon is not document. Weapon is a thing. Things are thing. Concept thing is not mentioned in the definition of evidence. But if oral evidence is connected with anything, then one must know second proviso of section 60 of Indian Evidence Act, and it is necessary to record the evidence of the person, of the witness who is adducing his evidence relating or connecting with the thing used by a party in the case. So far as criminal law is concerned, so far as CRPCs and IPC or penal provisions are concerned, if any weapon is used by the accused, then it is necessary for the investigating agency to seize the weapon. If the weapon is seized, then it is necessary for the investigating agency to produce the weapon along with charge sheet. As per section 170 subsection 1 of CRPC before the Honorable Court, and when adducing of evidence, it is necessary for the prosecutor to show the weapon to the relevant witness, and it is an expectation that the witness may say something about the weapon. Oral evidence of the witness connected with the weapon, as the weapon is connected with the offense, that is the case, that is the facts in issue. Facts in issue. Proved, disproved, and not proved. We know what mean by proved. Shabit Zali case. Not proved. Case is not false, but party failed to prove it. As prima facie case was on record, as per section 190, subsection 1, either small a or small b, because small a is for complaint and small b is for police report. Police report means charge sheet. Cognizance is taken. After taking of cognizance, it is necessary for the parties to substantiate the evidence, to substantiate the facts of the case by way of adducing of evidence. Party tried his level best to adduce evidence, but evidence is not that much sufficient. If evidence is not that much sufficient, then, or if acquittal, then the case or the situation or the circumstance comes in the ambit of not true. But if false case, as I am discussing with you false case, please go through criminal manual, chapter 1st, summaries. There are types of summaries. 3 summaries are given by a criminal manual. At the same time, I am inviting your attention on Maharashtra Police Manual also. Maharashtra Police Manual, to ascertain or to understand what mean by summaries. B summary is connected with, or we may say, it is necessary for the good reader while reading definition of disproved. Please go through B summary. Please go through B summary. At the same time, please read section 182 of IPC, giving false information to public servant by way of FIR. FIR is false, deliberately false, and hence B summary. So this is disproved. What mean by proved? Proved beyond all reasonable doubt, so far as criminal is concerned. So far as civil is concerned, preponderance of probability. Please understand the difference in between preponderance of probability and beyond all reasonable doubt. Beyond all reasonable doubt. Reasonable word is very, very, very important. Doubt must be reasonable. Then only acquittal. Then only acquittal. So, what is the difference between preponderance of probability so far as civil is concerned and beyond all reasonable doubt? By Indian Evidence Act. Proved, disproved, and not proved. Please read minutely definition of proved. Definition of proved. Because definition of proved, disproved, not proved applicable to civil as well as criminal. And definition of proved says or focus on preponderance of probability. At the same time, please understand the concept. I know that you know well, but please go through the concept circumstantial evidence. So far as preponderance of probability, which is applicable to criminal cases, please go through circumstantial evidence. And by this angle, please read definition of proved again and again, then disproved, and then not proved. After proved, disproved, not proved, 3 important terms: may presume, shall presume, and conclusive proof. 3 important words. Word provided is given in the definition of may presume. Whenever it is provided, word directed is given in the definition of shall presume. Whenever it is directed, and the conclusion Conclusion, the term conclusion is the significant part, is the significant aspect, is significant term behind conclusive proof. So far as may presume is concerned, the party may rebut the presumption by way of adducing of evidence or by way of cross-examination. Same is for shall presume. But what is the slight difference in between may presume and shall presume? So first of all, these two words, provided and directed. So far as may presume is concerned, the last line just I discussed with you while discussing definition of evidence. Court may call for proof of it. Court may call for proof of it is the last line of definition of may presume. This line is not mentioned in shall presume. There are 3 sections says about conclusive proof. Section 41, then section 112, and section 113 of Indian Evidence Act says about conclusive proof. Section 41, relevancy of certain documents in probate, etc., jurisdiction. Then section 112 and section 113. These are the 3 sections. Only 3 sections says about conclusive proof. There are various sections says about may presume. Important section is section 114, 114. Very, very important section. At the same time, I am inviting your attention on section 56 of Indian Evidence Act. Please read section 56 along with section 114, because section 56 says about fact judicially noticeable need not to be proved. There is connection in between section 56 and section 114. Judicial notice is provided by section 56, and presumption, may presume, is provided by section 114. I just discussed with you section 82 of IPC is also conclusive proof. Okay, 82. I will discuss with you. Please ask me the question at the end of my speech. Thank you. Yes, please go through section 56 while reading section 114 of Indian Evidence Act. While reading section 114 of Indian Evidence Act, I want to suggest you that please go through all illustrations. But so far as first 2 illustrations are concerned, illustration small a and small b. Illustration small a is regarding with theft, and illustration small b is for accomplice. At the same time, please go through section 133. What is the relation in between illustration small b, both b? 114 चे illustration वाचताना A to I हे दिलेले आहेत सरळ. I संपल्यानंतर 3 लाईन्स आहेत आणि ते संपल्यानंतर परत A to I दिलेले आहेत. So while reading section 114 of Indian Evidence Act, the reader must know both types of illustrations, first bunch and then second bunch. So far as illustration B is concerned, illustration B is accomplice. And whenever an issue of accomplice, I know that I am discussing with you about relevancy, but I feel that at the same time, it is necessary for me to discuss with you all these aspects which are connected with relevance. Tender of pardon to accomplice. Section 30 of Indian Evidence Act. Section 306, 307 and 308 of the Code of Criminal Procedure. So please read accomplice. At the same time, go through the provisions of section 133 and both types of illustrations which are given below section 114. What mean by may presume? Various sections may presume. Then please go through connectivity in between sections which are given under Indian Evidence Act. So far as map is concerned, presumption to map, presumption to electronic message, presumption to certified copies, presumption to confession given by accused. So some presumptions are may presume and some are shall presume. So far as certified copy of document is concerned, माझं बोलणं सगळ्यांना ऐकू येतंय काय?
Yes, sir. Video now stop.
माझ्याकडचे लाईट गेलाय असं झालं. हा ठीक.
Yes.
ऑडिबल आहे ना मी?
Yes, sir. Yes, you are audible.
ओके. 1-2 मिनिटं. We are discussing on presumption. So far as shall presume is concerned, for example, certified copy of public document. Public document is mentioned by section 74 of Indian Evidence Act. Its certified copy is mentioned by section 76. And presumption of certified copy is mentioned by section 79. That is shall presume. Confession of accused before Honorable Judicial Magistrate First Class by using of provisions of section 164 of CRPC. Such confession is shall presumed by section 80. These are the examples of shall presume. So example means sections. Various sections says about may presume. Some sections says about shall presume. And section 41, 112 and 113 says about conclusive proof. And now I am inviting your attention on section 5 that is very significant. आणि मगाशी जे मी म्हणालो Relevancy means section 6 to 55 and not by 5 to 55. So मी असं का म्हणतोय? Section 5 is mentioned by chapter 2 of the relevancy of facts. Though section 5 is given below chapter 2, that is of the relevancy of facts, it is necessary to go through the contents of section 5, the words which are mentioned, given by section. Evidence may be given of facts in issue and relevant facts. So please see, evidence may be given, party may adduce evidence of facts in issue. The definition of facts in issue just I discussed with you, and relevant facts. Relevancy is concerned. Evidence may be given in any suit or proceedings. Proceeding. Evidence may be given in any suit or proceeding of the existence or non-existence. Both aspects are mentioned here. Evidence of the facts which are in existence. Evidence of the facts which are not in existence. Both aspects are discussed here. Both aspects are expected by section 5 according to the case, according to the facts of the case. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue, and of such other facts as are hereinafter declared to be relevant, and of no others. So these words are very significant. Such other facts as are hereinafter declared to be relevant. Hereinafter declared to be relevant means section 6 to 55. And the relevancy which is given by section 66 to 55 is mentioned by section 5, and hence section 5 is quite different. Section 5 हा relevancy सांगतो, आणि सेक्शन 6 ते 55 मध्ये रिलेव्हन्सी दिलेली आहे. आणि म्हणून मी मागाशी असं म्हणालो की रिलेव्हन्सी मीन्स सेक्शन 6 to 55 and not 5 to 55. 5 says about relevancy. 5 says that the relevancy is given. Please go through section 6 to 55. And so far as the explanation of section 5 is concerned, this is very important explanation. So far as civil is concerned, this explanation is very important. This section shall not enable any person to give evidence of a fact which is disentitled to prove by any provision of law for the time being in force relating to civil procedure. If subsequent suit is barred by CPC, please go through section 12 of CPC. Order 9, Rule 8, Order 9, Rule 9 of CPC. Order 23 of CPC, withdrawal without permission. If permission and permission is not obtained. And the significant provision, that is Order 2, Rule 2, frame of suit. These are the relevant, these are the significant provisions which are necessary to be read along with explanation which is given below section 5 of Indian Evidence Act. And this is the situation of section 5. Section 5 is a connectivity of relevancy with the definitions. Section 5 is the connectivity by way of explanation with the civil procedure code also. And after this discussion on definitions of words and expression and presumption and section 5, Now we are actually entering our subject, that is relevancy, which is given under Indian Evidence Act. Though relevancy is given by section 6 to 55, but it is necessary to focus on section 6 to 16. Very, very, very important sections. Section 6, relevancy of facts forming part of same transaction. What mean by same transaction? Please read section 220 of CRPC. Please read section 179 of CRPC. What mean by same transaction? Section 6 is very important. Res gesti. The term res gesti is mentioned by section 6. What is the difference between direct evidence and hearsay evidence? That is also one of the significant part, one of the significant definition, one of the significant discussion behind section 6. Facts which though not in issue. See the opening line. Facts which though not in issue. And so far as this line is concerned, please go through provisions of section 11. Facts may not relevant, become relevant. आता नाही वाटत आहे, भविष्यामध्ये होतील. Facts though not relevant become relevant. At the same time, please go through provisions of section 136. That is very important. Judge to decide as to admissibility of evidence. What mean by admissibility of evidence? What is the difference in between relevancy and admissibility? Please read judgments on this aspect. Relevant वाटणारी गोष्ट admissible असेलच असं नाही. Please go through section 146 of Indian Evidence Act. That is one of the good example. Section 146 proviso of Indian Evidence Act. Though relevant, but not at all admissible. That is the example. Relevancy and admissibility. Section 136. Please go through provisions of section 136, first paragraph. There are other paragraphs also, but please go through first paragraph. Section 6. Facts which though not in issue are, it is not mentioned only connected. It is mentioned so connected. What is the importance of the word so? While the honorable author has mentioned the word so, facts which though not in issue are so connected with whom? With a fact in issue. For what purpose? As to form part of the same transaction. Are relevant. If it is so, then only the facts are relevant. Whether they occurred at the same time and place or at different times and places. Whether they occurred at the same time or different times, same place or different place. The scope is given, the scope is discussed. The scope to ascertain facts for pleading, so far as order 6 is concerned, order 6 of CPC is concerned, and the scope of investigation by chapter 12 of CRPC, and the significant section, that is section 156 subsection 1 of CRPC. That is the initial section by which investigation starts. So far as non-cognizable case is concerned, if permission by Honorable Judicial Magistrate First Class is obtained by section 155 subsection 2, then investigation. Then also opening of chapter 12. Though investigation is under chapter 12 of CRPC, or though the investigation is by section 202 of CRPC, both the investigations are also comes in the ambit of section 6. Whether they occurred at the same time and place or at different times and places. Same time and place or different times and places. As we are observing relevancy, section 7, section 8, section 9, and section 11 are the derivatives of section 6. आपण जर बारकाव्याने अभ्यास केला सेक्शन 7चा, 8चा, 9चा आणि 11चा, तर असं दिसून येतं की हे सर्व प्रोव्हिजोज आहेत सेक्शन 6चे. सेक्शन 6चे हे डिफरंट पार्ट्स आहेत. Facts which are the occasion, cause or effect of facts in issue. Facts in issue and the facts which are the occasion of the facts in issue, which are the cause of the facts in issue, which are the effect of facts in issue. So far as effect is concerned, practically I want to invite your attention once again on section 179 of CRPC. 179 of CRPC, twice or thrice I discussed with section 179 of CRPC. Please go through that section, very significant section, which is connected with section 6 and now section 7 also. Though section 179 of CRPC is given under CRPC, Criminal Procedure Code. Facts which are the occasion, cause or effect of facts in issue. So far as section 8 is concerned, we know well motive, preparation, and previous or subsequent conduct. Motive of the accused, conduct of the parties, conduct, previous conduct, and subsequent conduct. Previous conduct which is previous to the facts in issue, and subsequent conduct also which is subsequent to the facts in issue. Facts in issue means the case itself, the incident itself, the cause of action. So far as civil is concerned, cause of action for the suit, that is facts in issue. Reliefs arising out of cause of action. Bundle of facts is the conclusion of cause of action, and reliefs arising out of cause of action. Cause of action is the facts in issue. Motive, preparation, and previous and subsequent conduct. Conduct is not only of the accused, conduct of parties, conduct of representative of the parties relevant with, or this issue is relevant with civil. Conduct of conduct of the representative of parties, or the accused, or the informant, or the complainant, what it may be, or the witnesses. And there are types of witnesses: chance witness, by occasion they are there, why they are there, what is their conduct. So far as conduct is concerned, conduct of witnesses is concerned, I am inviting your attention on the significant judgment Rammi alias Rameshwar versus State of Madhya Pradesh. Rammi alias Rameshwar versus State of Madhya Pradesh. We are using this judgment for re-examination. Re-examination given by section 138 of Indian Evidence Act, direction of re-examination. But at the same time, so far as conduct of witnesses is concerned, I am inviting your attention. Please go through this judgment. Rammi alias Rameshwar. Section 9. Explanation or introduction of relevant facts. Explanation of facts in issue. Explanation of relevant fact. Facts which are necessary to explain the facts in issue, or facts which are necessary to explanation of the relevant fact. Please see. Facts in issue, relevant fact, and so far as section 9 is concerned, as we are going through section 9, facts which are necessary for the appropriate explanation of relevant fact or relevant facts, or which are necessary for the appropriate explanation of facts in issue. Facts necessary to explain or introduce a fact in issue or relevant fact. This is the first part of this section, which support or rebut an inference suggested by a fact in issue or relevant fact. Second part of this section, or which establish the identity of anything or person whose identity is relevant. Very important line. So far as identity is concerned, identification parade, test identification parade. Test identification parade, the basic section is section 9, and so far as this line is concerned, which establish the identity of anything or person whose identity is relevant. At the same time, please go through section 54 capital A of CRPC and section 291 capital A of CRPC. Test identification parade. Manners, how to conduct test identification parade are given in Criminal Manual, Chapter 6. So while reading section 9, so far as identification parade of person or thing is concerned, so far as identification parade of person is concerned, 54 capital A of CRPC, 291 capital A of CRPC, and Chapter 6 of Criminal Manual. Fix the time or place. Fix the time. Fix the time of incident. Fix the time of injuries. Fix the time of death. So all these aspects comes in the ambit of chapter 9, or which shows the relation between parties. Relation between parties is concerned. I am inviting your attention on section 50. Section 50 of Indian Evidence Act, relations between parties. To understand relation between parties, section 50 is given by Indian Evidence Act. Next section, that is conspiracy, conspirator. What mean by conspiracy? We know conspiracy, which is given by section 120 capital A and 120 capital B of IPC. But so far as basic section is concerned, section 10 is the basic section, which says about conspiracy. And I'm inviting your attention. I'm requesting you, please go through the illustration. Please go through the illustration below section 10 of Indian Evidence Act. So there may be a question in your mind, what is the importance of illustrations? Though illustrations are given under IPC or under Indian Evidence Act or various acts. So what is the value of illustrations? What to do with the illustrations? Whether illustrations are just to understand the provision or beyond than that. And to focus this issue, I want to invite your attention on section 6 of IPC. Please go through section 6 of IPC so far as illustrations are concerned. Section 6 of IPC. Section 11, when facts not otherwise relevant become relevant. I discussed with you. Read section 11 with section 6. Why? Facts not otherwise relevant are relevant if they are inconsistent with any fact in issue or relevant fact. Section 11 says about inconsistency. Second aspect, subsection 2. If by themselves or in connection with other facts, they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable, so far as highly probable is concerned. Term highly probable, which is given by section 11, is connected with section 6 of Indian Evidence Act, Res Gesti. So connected together is the term mentioned by section 6. Highly probable, either highly probable or highly improbable, plea of alibi. Plea of alibi comes in the ambit of section 11, not highly improbable. If highly probable, then section 6. At the same time, section 7, 8, 9 also, according to the situation. And highly improbable, plea of alibi. Plea of alibi comes in the ambit of section 11. Section 12 says about, now section 12 is for civil suits. In suits for damages, facts tending to enable the court to determine amount are relevant. Suit for damages, determination of amount. Determination of amount in suit for damages, so far as this issue is concerned, section 12. A right or custom. If any question of right, if any question of custom, then go through section 13. Section 14 is one of the important sections. Various illustrations given below this section. Why illustrations are given below this section by honorable author? That to see this section by various ways, various aspects. And that's why illustrations. Facts showing existence of state of mind or of body or bodily feelings. State of mind. Reasonable means ria, means reason to believe. Voluntarily, definition of reason to believe and voluntarily are given under IPC. Means ria is discussed by various judgments. And these issues voluntarily. At the same time, I am inviting your attention on the illustration given below, definition of voluntarily. Very important illustration. Because while reading IPC, in various sections, the opening line, the opening words are whoever voluntarily. Whoever voluntarily. So what mean by voluntarily? Please go through the definition of voluntarily. And to understand the definition of voluntarily, please read illustration given below, the definition of voluntarily. Please go through section 14 to understand what mean by state of mind, state of body or bodily feelings. Two explanations are given below this section. Both the explanations are very significant. Section 14 सांगण्याकरता बराच वेळ आवश्यक असतो. आपल्याला आता रिलेव्हन्सी मॅक्झिमम पूर्ण करायची आहे. जर पुन्हा चान्स मिळाला तर 14 वरती जास्त बोलता येईल. सेक्शन 8 अँड सेक्शन 14. सेक्शन 15. Facts bearing on question whether act was accidental or intentional. Whether acts, though acts, the word act is mentioned here. But at the same time, we have to focus on the term facts in issue and relevant facts. Whether the facts in issue are relevant facts or facts which are connected with facts in issue or the facts which are connected with the relevant facts are either accidental or intentional. So one has to bifurcate. While ascertaining the facts in the course of putting the fact before honorable court, in the course of conducting investigation of any cognizable offense or any offense, whether the act of the accused or act of any party, so far as party is concerned, either civil or criminal, so whether the facts which are connected with relevant fact or connected with facts in issue are either accidental or intentional. Next section is section 16. Section 16 is one of these significant sections. Why? Section 16 is connected with section 114 of Indian Evidence Act. Term business is mentioned by section 16. So what is the business which is mentioned by section 16? Duties of public servant or duties of any person, duty casted on any person or on any authority, any officer, public servant. That is the expectation of the business, the term business, which is mentioned in section 16. Please go through illustration G of section 114 of Indian Evidence Act to understand. Sorry, illustration F. Please go through illustration F of Indian Evidence Act to understand the exact meaning of section 16. For example, investigation of any cognizable case is going on. Cognizable offense is going on. In the course of investigation, as 3 persons are acquainted with the facts and circumstances of the case, hence investigating officer investigated towards these 3 persons as per section 161 of CRPC. As per section 161 subsection 3 of CRPC, it is for the investigating officer to record statements of these persons. He may record, he may not. It depends on the situation of the case, of the offense, of the information supplied by the persons. 161 statement is recorded. Use of statement 161 is only for contradiction. You know well. According to second part of section 145 of Indian Evidence Act. Signature of the person is not required. Signature of the person who is interrogated, examined by the investigating officer, signature is not necessary because opening line of heading of section 162 of CRPC says about no signature. But signature of investigating officer is necessary. Before me, signature is necessary. if the witness whose statement is on record is not supporting the case of prosecution on any significant aspect, or if any omission amounts to contradiction. At the same time, I am suggesting you, please go through the significant judgment, Tahsildar Singh versus State of Uttar Pradesh. AIR 1959, Supreme Court, page number 1012. And according to second part of section 145 of the Indian Evidence Act, if any part of statement under section 161 of the person is portion marked, and if the witness denies the portion, then the manners which are given by the judgment, just I discussed with you, the Sundar Singh judgment, it is necessary for the prosecution to call the investigating officer and to put the portion to the investigating officer by asking that who has given the information to you. And if the investigating officer has deposed that the information which is marked by portion is given by the witness itself, then the portion mark is proved, and it is necessary to give exhibit number to the portion mark. This exercise is given by Tahsildar Singh judgment as at the same time, or as well as chapter 6 of criminal manual. Investigating officer is public servant. While exercising provisions of chapter 12 of CRPC, and most significant, while exercising provisions of section 161 of CRPC, he has recorded the statement of the person who is acquainted with the facts and circumstances of the case, and the witness is not supporting, then the portion mark is proved. This discussion I discussed with you on section 162 of CRPC, that is omission amounts to contradiction. This discussion, the duty of the investigating officer comes in the ambit of section 16. So also illustration F of Indian Evidence Act, that the common course of business has been followed in particular case. Common course of business, recording of evidence of the person is the common course of business of the investigating officer. He has performed. Accused may ask questions that you have not performed. It depends on the cross-examination by the accused. This is an example to focus the provisions of section 16. After section 16, admissions, section 17, admission by parties. While reading section 17, please read section 21. And please go through illustrations given below section 21. There is interconnection in between section 17 and section 21. And to focus on the provisions of section 21, please go through illustrations given below section 21. Section 17, 18, then section 19, 19, 20, and connection which I have given by section 21. So far as this aspect is concerned, extrajudicial confession is given by section 24. Extrajudicial confession is by section 24. Extrajudicial confession is by section 24. Judicial confession is by section 164 of CRPC. Section 164 of CRPC having connection with section 26 of Indian Evidence Act. Section 26 of Indian Evidence Act, section 164 of CRPC, judicial confession. Section 24 of Indian Evidence Act says about extrajudicial confession. While reading extrajudicial confession, at the same time, please read section 163 of CRPC. person in authority is one of the significant term mentioned by section 24 of Indian Evidence Act. And with that connection, I am suggesting you please go through section 163 of CRPC. Then section 25, confession before police is not admissible. Now see, confession to police officer not to be proved. Why not to be proved? Because confession before police is not admissible. At this juncture also, we have to apply our mind on relevancy and admissibility. Confession before police is relevant, though not admissible. Term admissibility is connected with first paragraph of section 136 of Indian Evidence Act. Judge to decide as to admissibility of evidence. If the fact is relevant and admissible, then it is necessary to accept it by way of recording of evidence. Though one fact is relevant, but it is barred by any law, its admissibility is barred by any law, then though the fact is relevant, it is not admissible. Same is for section 25. As same is for section 25, and hence memorandum of accused. Section 27 of Indian Evidence Act. Very important section, section 27. To understand section 27 of Indian Evidence Act, I am suggesting you, please go through the judgment. I am very sorry that frequent judgment of Pulukuri Kottayya, 1947 Privy Council. Fact discovered. What mean by fact discovered? But prior to go through provisions of section 27 of Indian Evidence Act, we must know the provisions of section 25 and 26. Provisions of section 25 and 26. Section 26 says about confession by accused while in custody of police not to be proved. Now, what is the difference in between section 25 and 26? Section 25 says that confession to police officer not to be proved. Confession to police officer. And section 26 says that confession in the custody of police officer. So this is the difference in between section 25 and 26. Confession to police officer, 25, barred. Section 26, confession by accused while in the custody of police not to be proved against him. Though it is so, but the way towards section 164, that is judicial confession, starts by section 26 itself. Please go through the provisions of section 26. And section 27 is the proviso of section 25 and 26. Because opening line of section 27 is provided that when any fact is deposed as discovered, by whom? The accused. Where is the accused? In the custody of police. Please understand, not police custody. एक minute. Doctrine of confirmation. Doctrine of confirmation is the base of section 27. So please go through doctrine of confirmation. Please go through judgment. Just I discussed with you. Pulukori Kottaya. Please go through judgment of Damu versus State of Maharashtra. So also judgment of Rumi Bora Datta versus State of Assam, to understand what mean by section 27. Thing is not discovered. Fact discovered. Fact discovered is the significant part, significant aspect by section 27. Thing is not discovered. Huh? Please understand. Fact discovered. So what mean by fact discovered? Pulukori Kottaya. First of all, go through Pulukori Kottaya. Read Pulukori Kottaya again and again, to understand what mean by fact discovered. I know that various questions in your mind arising out of section 27. And questions are probable. Questions are expected. But prior to ask any question, you may ask the question. You are free to ask the question. I am here to give answer. You may find out the question. But prior to ask any question or prior to go through any answer, even by anybody, you have to read Pulukori Kottaya judgment. Then section 28. Section 28 having concern with section 24. Section 28 having concern with section 20. Section 24 says about extrajudicial confession. And section 28 says confession made after removal of impression caused by inducement, threat or promise. Inducement, threat or promise, if confession is by inducement, threat or promise by person in authority, then it is not an extrajudicial confession. But if the impression of inducement, threat or promise is removed, then section 28. Section 29, confession otherwise irrelevant not to become irrelevant because of promise of secrecy. And just I discussed with you section 30, important section. Section 30, accomplice and relevant provisions. I discussed with you section 306, 307 and 308 of CRPC. So also section 133 of Indian Evidence Act. Section 32 and section 33. There are 8 aspects of section 32. First is dying declaration. recording of dying declaration. Expectation of death. When the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes in question. Such statements are relevant whether the person who made them was or was not at the time when they were made under the expectation of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. So expectation of death, he may expect, he may not. While reading section 32 subsection 1, that is dying declaration, it is my suggestion to all of you, please go through provisions of section 158 of Indian Evidence Act. It is necessary to read section 158 along with section 32 subsection 1, that is dying declaration. How to prove dying, how to record dying declaration, who may record dying declaration, and how to prove dying declaration, proving of document. In fact, dying declaration is a document. Proving of contents of dying declaration, proving of signature or thumb impression of the person who has given dying declaration. At the same time, section 150, 158, very significant section. Please go through. Section 33. बऱ्याच वेळा प्रश्न असा असतो की चीफ एक्झामिनेशन झालेली आहे आणि काही कारणामुळे क्रॉस एक्झामिनेशन राहून गेली आणि तो पर्सन आता येत नाही किंवा तो पर्सन इज नो मोर, ए पर्सन इज अनेबल टू कम बिफोर द कोर्ट, त्यावेळेस काय करायचं? If cross examination remained or not completed due to the reason or reasons which are mentioned in section 33, then the chief examination which is on record is relevant. Is to the extent of relevancy, because section 33 is one of the section in between section 6 to section 55, and that's why section 33 comes in the ambit of relevancy. Such chief examination comes in the ambit of section 33. After section 33, section 35 says about relevancy of public record, necessary to prove the relevancy, the public record. If necessary to examine the author of public record, necessary to examine the author to prove the contents of public record. If public record is of public document, which comes in the ambit of section 74, and if certified copy of such public document which comes in the ambit of section 76, then as per section 79 of Indian Evidence Act, as the certified copy, though it is a secondary evidence by section 63 subsection 1 of Indian Evidence Act, as per section 79 of Indian Evidence Act, certified copy of a public document shall presumed as public document. Certified copy shall presumed, no need to examine the author. Shall presume. Otherwise, if the document comes in the ambit of only section 35, because we are discussing section 35, it is necessary to examine the author to prove the contents of the document. Section 36, please read section 83 and 87. While reading section 36, please read section 30, section 83 and 87. While reading section 37, please go through section 81. 81. Now I will jump directly on experts. Section 45. Foreign law, science, art, as to identity of handwriting or finger impressions. Opinion. While reading section 45, please read section 73. And at the same time, section 311 capital A of CRPC. Section 311 capital A of CRPC. This is the combination. At the same time, please go through Maharashtra Police Manual. How to obtain specimen handwriting and specimen signature. At the same time, please observe the reports by the investigating officers to the experts. Questionnaire. How to establish questions which are related with the things and documents. Section 46 is one of the different sections. Section 11 and section 46 are similar sections. Section 11 of Indian Evidence Act and section 46. Why? Because section 46 says facts bearing upon opinions of experts, facts not otherwise relevant. See the construction of the section 46. Facts not otherwise relevant are relevant if they support or inconsistent. If either they support or inconsistent with the provisions of experts, with the opinions of experts, when such opinions are relevant. So while reading section 45, it is necessary to go through section 46. So also section 11 of Indian Evidence Act. So also section 6 of Indian Evidence Act. This is the art of reading. How to read laws. Section 47 capital A is for digital signature, because section 47, just I discussed with you, the person who is acquainted with the handwriting and signature. Examination of such person. Section 47A is opinion as to digital signature relevant. So far, digital signature is concerned, section 47 capital A. Then customs are given. So far as character is concerned, our schedule is so far as character is concerned, 52, 53, 54, 55. Character is the last part. Section 6 to 55. So far as character is concerned, I want to suggest you that please go through section 53 capital A. Evidence of character of previous sexual experience not relevant in certain cases. So what mean by relevancy and admissibility? Just I discussed with you proviso of section 146. In connection with the proviso of section 146 and in connection with the discussion on relevancy and admissibility, please go through provisions of section 43 capital A of Indian Evidence Act. evidence of character of previous sexual experience not relevant in certain cases. So थोडीशी घाई झाली, 2-3 वेळा इलेक्ट्रिसिटी पण गेली. अपार्ट फ्रॉम दॅट अजूनही जास्त वेळ जर मला भविष्यामध्ये मिळेल तर मी ह्याविषयी अजून डिटेल बोलेल, नक्कीच बोलेल. कारण काय असतं की एक प्रोव्हिजन कधीच एकटी नसते. त्या प्रोव्हिजन्सच्या बरोबर इतरही प्रोव्हिजन्स सगळे असतात. अँड इट इज आय फील दॅट इट इज नेसेसरी टू गो थ्रू व्हेरियस आस्पेक्ट्स, व्हेरियस प्रोव्हिजन्स which are related with the provision under discussion, and hence as the subject which is given to me, that is relevancy section 5 to 55, I feel that I tried my level best to cover this subject. Thank you. Ganesh ji. Ganesh Pawar. Ganesh. Ganesh.
Good evening, sir. Am I audible? Hello? Am I audible? Hello. Good evening, sir. Am I audible, sir? On behalf of Bar Council of Maharashtra and Goa, before expressing vote of thanks, I would like to congratulate Milind Datrange sir for his appointment as the Additional Public Prosecutor of Sessions Court, District Court. Congratulations, sir. Now I express sincere vote of thanks for today's enlightening lectures on relevancy of facts and how the Indian Evidence Act to be read with all the provisions of CPC, CRBC and all the manuals as well as the basic principle that when we are conducting any trial, how to refer the police report also. This is the actual key guidance given by sir. Thank you very much, sir. Now, today I express very sincere thanks for Milind Datrange sir, as sir has put forth an example that इच्छा तिथे मार्ग. कारण even though there was interruption of power supply, sir continued his lecture the manner in which we all have observed. Now, this shows that sir's commitment towards his duty. Thank you very much, sir. Once again, I would like to thank all the participants for joining the lecture, and I am sure this lecture will certainly help all the participants who are going to appear for mains of JMFC as well as conducting any trial. Thank you very much, sir. Thank you.